Board of County Commissioners acts as a quasi-judicial body when it hears requests for rezoning and conditional use permits. Applicants must provide competent, substantial evidence establishing facts or expert witness opinion testimony showing that the request meets the zoning code and comprehensive plan criteria. Opponents must also testify as to facts or provide expert testimony whether they like or dislike a request is not competent evidence. The board must then decide whether the evidence demonstrates consistency and compatibility with the comprehensive plan and the existing rules in the zoning ordinance, property adjacent to the property to be rezoned, and the actual development of the surrounding area. The board cannot consider speculation, non-expert opinion testimony, or poll the audience by asking those in favor or opposed to stand up or raise their hands. If a commissioner has had communications regarding a rezoning or conditional use permit request before the board, the commissioner must disclose the subject of the communication and the identity of the person, group, or entity with whom the communication took place before the board takes action on the request. Likewise, if a commissioner has made a site visit, inspection, or investigation, the commissioner must disclose that fact before the board takes action on the request. Each applicant is allowed a total of 15 minutes to present their request, unless time is extended by majority vote of the board. The applicant may reserve any portion of the 15 minutes for rebuttal. Other speakers are allowed 5 minutes to speak. Speakers may not pass their time to someone else in order to give that person more time to speak.
All right, welcome everyone. We're going to go ahead and get called to order at 5 o'clock on the dot. We'll start out with item B, a moment of silence. Commissioner Pritchett? States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, ma'am. All right, we don't have any minutes for approval today. We don't have anything under item E as an echo under resolutions, awards, and presentations. We do have the consent agenda, items F1 through and inclusive of F4. F3 has been deleted. I do want to put on the record, I've spoken with Ms. Bentley about items F1 and F2. I serve on the board for the other organization that we'll be contracting with, and she's verified that there's not a conflict insofar as my voting on this. Is that fair to say, Ms. Bentley?
That is correct.
Okay, so with that said, I'm just taking a look here. In addition to items F1, 2, and 4, noting that 3 has been deleted, I see that for items H2 and H3, the only card that we have, Commissioner Smith, is the applicant. I don't know what your position is with respect to that, but perhaps we could have staff do a quick intro for H2 and H3, and then move along with passing consent to also pass H2 and H3, given that we only have the applicant at this point. So staff, if you could give us just a quick intro on H2 and H3, I think we can knock a few birds out with one stone.
Thank you, Mr. Chairman. Both of these are companion applications. Brevard Medical City LLC requests an adoption of the 2019-2.2 large-scale comprehensive plan amendment to change the future land use designation from planned industrial to community commercial. It's located in District 4, which is Commissioner Smith. H3 is the zoning, which is Brevard Medical City LLC, Brevard Medical City Owners Association, Inc., and Chateau Madeline LLC requests a change of zoning classification from PUD and PIP to all PUD with the retention of a CUP for the alcoholic beverages, full liquor, and an ALF assisted living facility with a waiver request for the building separation between an existing and proposed ALF expansion. This is also in District 4, which is Commissioner Smith. Thank you.
Thank you, sir. So, Commissioner Smith, I don't know where you are with it, but if you are inclined to approve it, we can take care of it all in one fell swoop with F1, F2, F4, H2, and H3. All right, could we have a motion from you on that end?
Can we just clarify for the record that
Sure.
The zoning items are under the public hearing section, and you have no one in the audience to speak, you have no cards, and there's no objection to proceeding at this time.
I think you clarified the record.
Thank
and
you.
Just to add a teensy bit of additional clarification, the only card that we do have is the applicant's card, and I cannot imagine they're going to be upset if we approve their items. So We're going to go on ahead. I've taken the motion from Commissioner Smith. I'll go ahead and second it to approving F1, F2, F4, H2, and H3. I'll call the question. All in favor of approving those items, say aye. Aye. Any opposed? All right, F1, F2, F4, H2, and H3 are unanimously approved. Thank you. Thank you. All right, so we will move on here. There is no, let's see, nothing planning and development, nothing county manager. Oh, I'm sorry, county manager we already approved. Public comment, there's nothing in the general public comment section. They're just item specific. We'll move right on to H1 here. With respect to H1, I do have some disclosures in addition to those that I've already provided to Cheryl with clerk to the board. I corresponded extensively by email with nearby residents Robin Sylvia, Judy Gustafson, and I believe her husband Carl, same last name, all of whom are opposed to the proposal. We've gotten numerous emails, and I've exchanged numerous emails with these individuals from Monday, September 28th through Wednesday, September 30th. From Friday, September 25th through Thursday, October 1st. I've also corresponded with the HOA's attorney, Kevin McCann, via email and then to a limited degree by text message, in addition to having met with him in person on Monday, September 28th. On the 29th of September, William Jefferson emailed my office expressing concern over the proposal. I spoke with Rachel Sadoff regarding the proposal on or about Friday, September 25th. And I've also asked Planning and Zoning Manager Jeffrey Ball to relay my request that the applicant consider a BDP limiting the number of lots and or the number of septic systems on the subject property. I understand that my request was conveyed to the applicant who did reject it on or about Tuesday, September 29th. So Jeff, before I say anything else on this, could you go ahead and give us an intro on the item?
Sure. H1 is Carmen Francie requests a change of zoning classification from AU to EU. The project is located in District 2, which is Commissioner Lober. I wanted to point out that during the planning and zoning meeting, the applicant acknowledged that since the Curry Dell Road is a private road, they cannot utilize it for access. They will need to ensure that the proposed lots will have adequate access during the subdivision phase, and access may be limit their lot yield. Thank you.
Thank you, sir. So I have just a few things on this item, just to kind of give everyone the benefit of at least knowing where I am before we have public comment. And if you want to address your comment accordingly, you're certainly welcome to, or not, depending on what you'd prefer. So the things that we're entitled to consider in deciding a zoning change proposal are number one, the county's comprehensive plan, including any administrative policies, two, the compatibility with adjacent and nearby properties, and then three, the consistency with adjacent and nearby properties. So numerous concerns have been brought up by nearby residents, including those related to financial aspects of potential development or potentially lack thereof. We can't lawfully consider those in evaluating the rezoning. I'll give you another example. The potential number of lots a developer could place on the property, to my understanding, is not a factor that we can lawfully consider in evaluating a rezoning request. And I'll just, so you know, I'm not making it up. Ms. Bentley, is that a fair statement?
Insofar as you can consider density as part of the zoning classification, yes, but that's all tied to the number of the lots. So it's an overall density question, not a number of lots in a subdivision plat question.
So I would say it's undeniable that there are a tremendous number or a tremendous amount of EU zone property immediately adjacent to and near the subject property. And I certainly acknowledge that there is a smattering of SEU nearby, but all of it, or substantially all of it, is on the riverfront lots on the east, not on any land that's to the west of Courtney in that area. So the subject property, when I look at it on the map, is essentially an island of AU in a sea of EU. The overwhelming majority of the contiguous property is zoned EU, both to the north and the south. The county would have an incredibly hard time, in my opinion, defending the position that the proposed rezoning is not compatible and consistent with the nearby and adjacent parcels. I would say to ignore the applicable law and to deny the rezoning request would essentially force taxpayers to eat legal costs, both on our end and potentially on the other side, in defending what appears to me at least to be an unjustifiable position that would have the effect of simply delaying the inevitable conclusion that they're entitled to the rezoning. So, you know, I think that while it's perhaps unreasonable to expect that someone else's land will remain undeveloped forever, it's also, by the other side, it's far more reasonable to expect that land won't be overdeveloped. And I think that's really where the concern lies. So I empathize with the neighbors. I can tell you because I wouldn't want to see 11 lots and by extension 11 septic tanks introduced into the subject property, which incidentally is sandwiched smack dab between the Indian River and the Banana River on the south end of Merritt Island. Quite possibly, it may be the worst possible location to add additional septic tanks in the county. However, I don't believe that that's something that we can legally consider with respect to the rezoning application. And Ms. Bentley, if you have a different opinion, certainly anytime you'd like to interject, I welcome you to do so. Importantly, though, I think that it's worth mentioning that these and other concerns raised may be considered in the future when waivers are inevitably sought during the site plan process, which will undoubtedly follow the rezoning. So while the site process plan is typically handled administratively, given the intense development plans of which I've heard talk, I'm not comfortable leaving it with staff to deal with on that end. So to that end, following public comment, I would ask that any motion that may be offered by one of my colleagues to approve the rezoning include also the following language: that staff be directed not to administratively grant any waivers of any development standards without the express approval of the Board of County Commissioners, and that staff be further directed to apply the most stringent lawful standards in analyzing any such waiver proposal or proposals. So assuming that this proposed language is included in the motion and it passes, I would encourage residents to remind the other four commissioners when this comes back to us of their concerns regarding potential overdevelopment of the land and the impact that it likely or almost certainly will have on neighboring properties and on the Indian River Lagoon. I'll just say this before I turn it over to public comment as well. The applicant is entitled to a total of 15 minutes to introduce the proposal, to have any experts speak, and time permitting to rebut any opposition testimony. While I don't intend to cut anyone off mid-sentence, I am going to strictly enforce the time limit with respect to this. I think we have enough speakers that it's something that we need to keep corralled. Everyone else is going to have a full 5 minutes to speak, and as we've seen in the intro that was played at the start of this meeting, no one can cede any portion of their time to another. For today's purposes, I would just encourage all speakers, whether the applicant or whether folks opposing the application, that they focus their comments, at least today, on whether the proposed rezoning complies with the county's comp plan, including the administrative policies, whether it's consistent, and whether it's compatible with adjacent and nearby properties. Anything that you think we ought to add, Ms. Bentley, before I turn it over for comment?
You can talk about the existing development in the area.
Tad, I think you might be a little better versed with respect to that, or Jeffrey?
So in this area, as you mentioned, there's quite a bit of EU development, which looks like it has the same lot size, or I should say the minimal lot size, which is 100 by 100 in that. So that would be the minimum lot size that would be required here, which is consistent with what's in the neighborhood and throughout the area. There are some larger lots, but that's the minimum lot size. And when the larger lots, it just depends on how the land was split up. In this particular case, I think that the concerns that you mentioned is because the lot is very narrow, that when we look at subdividing that property is when we start getting into our standards, there's not enough lot width to begin with that would allow for the typical right-of-way sections and the buffer tracks that the subdivision codes required that would allow the lots to be that minimum width or that minimum depth of 100 feet. So that's where the concern, I believe, comes in. And
just for clarity's sake, to make sure that we're all on the same page with this, with respect to the language that I just read that I requested accompany any motion to approve this, I spoke about having to have any waivers of any development standard come back to the board. Would you say it's a fair statement that a right-of-way waiver, for instance, would be a development standard waiver?
Yes.
Okay. I just want to make sure everyone, myself, yourself, and the folks that are listening in the audience
Yes.
are all on the same page with that.
I would take that to mean that any waiver through our subdivision code standard requirements would need to come back to the board, would not be allowed by that direction or by that motion, would not be a administrative waiver to be considered by staff.
All right, I appreciate it, sir. Okay, so I'll let you all know the order that I'm going to have folks come and speak, just so that you can get yourself ready and be essentially set to come up and say what you'd like. The applicant will come up first, Michael Weaver from Melbourne. He'll have a total of 15 minutes, including to offer any expert or other testimony for folks that he's brought with him that are not speaking as members of the general public. After that, we'll have Robin Sylvia, and I apologize if I'm mispronouncing anyone's name, from Merritt Island, Scott Price then from Merritt Island, Bill Jefferson from Merritt Island, and then attorney Kevin McCann from Merritt Island. So let's go ahead. We'll start up with Mr. Weaver from Melbourne. Welcome, sir.
Good evening. My name is Michael McGuire.
Oh, I apologize. McGuire.
Yeah.
Whew, you should be a physician with handwriting like that.
You know,
My
maybe after
apologies.
tonight I will. We've come before you tonight to get a rezoning on this property that's currently zoned AU. Consistently right now with the AU zoning, we do not have enough width to meet the requirements for the AU zoning. The EU zoning is prevalent throughout the entire area. I don't believe that I've given up any position that I wouldn't try to access Curry Road. We believe right now that the HOA does not own that road. That's currently a legal action going on, and nobody knows how that's going to end up. So we believe that this is the correct zoning for this property, and I'd like to save my time for rebuttal.
Okay, I'm going to save the remaining time you have for rebuttal, but before you step away, just with respect to your plans, just for the benefit of the folks that are here in the audience especially, is it your plan to wait to see how that pending litigation pans out before you do anything with respect to trying to further the development of the property, or are you looking at pursuing that concurrently with the litigation
Concurrently.
ongoing? Okay, I appreciate it. All right, so we'll have Robin Sylvia? Did I pronounce it correctly? Okay, at least I got one for two. Thank you.
Thank you. I'm trying to talk very quickly. Okay. Hello. My name is Robin Sylvia. I reside at 3800 South Courtney Parkway, adjacent to the fancy property on the Banana River side.
Actually, I'm going to restart your time.
Yes.
I think the mic was off there for a
Oh,
moment.
is it?
Could you
Okay.
try again? I apologize.
Hello. Can you hear me?
Are we getting her?
Sort of. Do I need it like
Yeah, maybe a little closer.
Okay.
Thanks, Don.
Oh, maybe that? Okay. Can you hear me now?
All right,
I feel
we're
like
good.
testing.
Okay, I'm not going to make you reintroduce yourself, but
Okay.
you've
Well,
got the
I
floor.
reside
Thanks.
on the Banana River side, on the northeast side of the fancy, I hope I'm saying that right, property. I am a lifelong resident of Brevard County, and I'm here to voice my opposition to the rezoning request and respectfully ask that you reconsider the committee's recommendation, which was not unanimous in its favor to have the status changed. I would first like to thank you, Commissioner Lober, for all that you've done, your staff, the exhaustive outreach and research that you've done on this. So thank you so much for that. I really appreciate it, because sometimes you think that your voices aren't heard out there. I would like to, though, however, address three issues that seem to come up, and I know that came up in our emails. First is the merits. Is it consistent with the request? Second, the entitlement of the landowners to make, or not even landowner, soon to be landowner, to make this status change request, and also the precedents that it established. First, on the merits, the question is the request consistent with the surrounding property? And I know that there's a lot of EU there, but I'd argue that it is just as consistent to maintain the current agricultural usage as it would be to change it. That there is more, I respectfully disagree, than a smattering of farmland. I can stand on the corner of the property and throw a rock, and I do not have a good arm, throw a rock and hit a 10-acre mixed fruit farm, over 10 acres, from river to river, just one plat south. So that's something to consider at least. And I would also argue that there's more agricultural acreage from Pineda north to the property line than we tend to realize. You only have to look at the aerial maps of river-to-river estates that still maintain their agricultural status, or drive south down South Tropical Trail during mango season to see all of the fruit stands that people are selling fruit along that road. So all things being equal, I think they both have merit. Second, the question of entitlement. It has been said that the developer and out-of-state owner are entitled to request a status change. Yes, they are entitled to request it. However, they are not entitled to it being approved any more than the homeowners are entitled to oppose it. Okay? Otherwise, we wouldn't be having this meeting tonight, okay? The only people that are entitled to make that decision are you guys, are the Board of County Commissioners. You guys are entitled to make that decision in the best interest of the county. As a side note, I would also argue that collectively the surrounding homeowners pay many more times in property taxes and should at least be given equal consideration. And as far as the question of precedence, there is only precedence of land usage change because a board, not saying this board, has approved it in the past. I would ask, is there any scenario, ask yourselves, is there any scenario where you would not approve this? Any amount of public opposition big enough, any land too important that you would not approve it? If not, then we can extrapolate that into the future where every request along South Tropical Trail is approved for status change. And what would that look like? Would it look like the minute you get off on South Tropical Trail, there's subdivisions, cleared land, a 4-lane highway? At some point, okay, we have to think that way. Somewhere along the line, a board in the future will hopefully recognize the importance of preserving a Brevard County gem, such as South Merritt Island, in that it benefits all of Brevard County, similar to Cocoa Beach. Their beaches benefit everybody. Indian River Drive, Riverside Drive, think of the gems of Brevard County, okay? It's what makes living in Brevard special and should be preserved for the future. I ask that you start a new precedence this evening with this board. Finally, if you cannot see to turning this down, then I would only ask that you look out for the homeowners by making the approval tonight contingent upon waivers and any variances. That it would come back to the board so it can be out in the sunlight, and only because the developer's plan is so very aggressive, I think it needs to have a second look along the site process, which is normally closed to the public. So I appreciate your time, and I think I talked way too much.
Thank you. I think Commissioner Znaidy may have a question for you.
Yes,
Can you tell me again where you live, and do you live in a subdivision?
I don't.
Okay.
I'm probably the least affected person in this, but if you look at the people that live on that HOA, they don't even have a road. It is so intrusive, like it just blows my mind. I'm actually on the Banana River side, and I think I would be probably the least impacted to this. It's just if you go out to the site and look at it, it's what he wants to do, and you can hear, and I don't want to, but if he gets approval, it's going to go. He's litigating for that road. He's pushing for everything. So that's where I asked you guys to just think about the gems that are still in Brevard County. When I was growing up, we used to take South Tropical Trail, pick oranges. It's a part of being a lifetime resident of Brevard County that needs to be protected.
Thank you.
Thank you.
Appreciate it. Thank you. All right, next up we'll have Scott Price. Welcome, sir.
My name is Scott Price. I am a resident of 1262 Currydale Lane. I am the original resident I bought the first home there. So I've been there since day one. Currydale Lane, of course, as you know, has 9 lots. We have an active HOA, which I'm the president, and I am speaking on behalf of the residents themselves. Our HOA, Rockwell South, has the responsibility of maintaining Currydale Lane and the common area for the past 14-plus years, and that's being provided no assistance from the county or from the original developer, Mr. Tom Curry. The residents of this small community purchased their homes primarily due to the fact that it was limited number of homes, being on a private street, the privacy of the street, and having an HOA and low vehicle traffic on that road. I know when I purchased my home, I had done my research, personal research, with respect to the potential future development of what might be around that street. And of course, the south side of the property in question is really what I did my research on. When I did my research, it's undeveloped. I understood who owned the property, somebody in Georgia, the name Carmen. And I did check the plat, and the plat, they have access. It's not landlocked. It has access to the south of that property on the east off Courtney Parkway and Tropical Trail. And over the years, I've had the opportunities to speak with the original developer of Currydale Lane. That was Mr. Tom Curry, who passed away this past summer, who told me that back in the 90s, he provided an opportunity to Carmen Francie to pay half of the development cost of the road of Currydale Lane. That went on, he got a negative response on that. So he then went ahead and completed development, made sure that the road was on his property, and created an HOA and filed with the county. That was in the 90s. Mr. Curry completed the development of Currydale Lane and filed his HOA covenants with the county, as he told me, to ensure it would remain private and accessible to only its homeowners. The homeowners would be in control of their future living on Currydale Lane with the filed covenants that he drafted and still remain in effect to today. These covenants note all the transfer and the rights and responsibilities of the road and the common area to the Rockwell South HOA many years ago. Now we have a developer who wants to come in and purchase the property in question to our south and wants approval for 11 home sites, 11 home site development, and wants access to our road to do this. If this plan was ever to be allowed and access to Currydale Lane provided, this will more than double the homes, over double the traffic on a small circle drive in Merritt Island on our road. And we believe, the homeowners believe, will devalue our current properties of Currydale Lane due to overcrowding and congestion in our street. This doesn't even account for the years of construction, its traffic, damages, environmental impacts that we will all incur for the next unknown amount of time. As president of the HOA, of the Rockwell South HOA, there is no plan to ever allow or grant access to Currydale Lane to the developer, and there's 100% consensus on this issue. We feel the property in question to the south is platted, not landlocked, and has provided 2 access points to that property on its south side from Courtney Parkway and South Tropical Trail. The developer has an alternate plan of developing this property that can use those access points. The alternate plan is less destructive to the environment, less invasive to the surrounding properties by subdividing into larger parcels, but much less homes. That's not his objective. His objective is to cram 11 home sites onto a small street, and there is no consideration of the current residents of Currydale Lane at this time. The residents of Currydale Lane would ask the board for consideration for not approving any measure that would allow this developer to potentially develop this property in question as he wishes. We ask that only approve, if approved, only his alternate plan be approved. Any approval of his primary objective will destroy the current residents, destroy why the current residents of Currydale Lane bought their homes in the first place, for its privacy, peacefulness, uncongested, and a respectful small community. I would ask the board to consider these residents. Please consider the residents of the surrounding area and only approve the least invasive plan for the benefit of the community versus the developer. Thank you.
Thank you, sir. Just a question for Tad and for Jeffrey. Assuming for the moment that the rezoning is approved, without getting waivers, do you see any way in which 11 home sites could be fit in the subject property?
I don't believe that 11 homes would fit on the property with the width constraints that it has without seeking some waivers, and that's also without having access to Currydale Lane.
I appreciate it, sir. All right, next up we'll have Bill Jefferson. Welcome, sir.
Thank you. Yes, my name is Bill Jefferson. I reside at 3750 South Tropical Trail. My property is probably the property that will be most impacted by this development. I have a property line that covers 3 acres adjacent to where this area needs to be developed. Under either development, there's going to be years of turmoil and destruction to the property. When it comes down to the flag lots, we have no idea even what sort of access they're looking at the flag lots. Are they going to put a road all the way through that property? Are they just going to limit the access from Courtney and South Tropical? We have no idea what they're doing. And, you know, I've been a proud Florida resident for the fourth generation. And what I see is between Courtney and South Tropical, we've got precious little natural resource left. We've got Rotary Park, and we've got this property. There's not much else there. You know, when over the years, I have local contractors come out to my house, electricians, plumbers, carpenters, without exception, the one thing they say is, wow, I didn't know anything like this still existed on Merritt Island. And they're right. There isn't much left. The property sites around this area are 1, 2, and 3 acre home sites. Directly to my south is 7 acres, which is still zoned agricultural. I just don't see how putting a subdivision in that area goes with the same spirit of what is already there. It's going to be years of turmoil. You know, we have long-term nesting owls, hawks. Those nesting areas are going to be completely disturbed by all of this construction. You know, these are federally protected species, not to mention numerous colonies of gopher tortoise that have been there a lot longer than we have. We have old-growth oak trees. You know, the way that he has got this segmented out, it looks like he's developing a prairie land, not some place that has living environment to it. I would implore the commissioners to take this into consideration, that this is not in the spirit of what is going on in that neighborhood right now. Thank you.
Thank you. Ms. Bentley, I'm kind of trying to stretch to find any lawful reason I could shoot this down. I'm just going to be blunt with you. Can we consider, or are we in any way entitled to consider, the fact that that is the only, or one of the only, I should say, remaining vacant pieces of land in the area?
Not in that direct ascent concept like that, but you are, under the administrative policies, allowed to look at all the surrounding uses. So you're going to have to look to the north and the south in order to make your judgment under your administrative policies.
So if there is no nearby, adjacent, north, south, well, east and west, you end up hitting the river in short order, respectively, on both sides. Assuming there's nothing similar to it in the immediate vicinity to the north or the south, where does that leave us?
If it is appealed, the court will be looking at whether or not the surrounding uses are consistent and compatible with the proposed zoning. And if they are consistent, and that's the comp plan portion of the future land use map, the staff comments already have indicated that it is consistent with the future land use map. So that leaves you with only compatibility. A desire for vacant land adjacent to the property is not a valid basis for denial. However, you can look at the development surrounding it and make your judgment accordingly. Pursuant to the criterion policy 3, it talks about lighting, odor. Is it a material reduction in land value? Is it consistent with an emerging pattern or an existing pattern? Historical land use patterns, actual development approved within the last 3 years.
Is there anything out of that list that you've just gone through, or anything else that you think we're entitled to lawfully consider, that would give you any degree of comfort with respect to defending a lawsuit that results in our denying the request, or results from that?
I would certainly do my best to defend the board's decision.
As you always would. I appreciate that's a diplomatic answer. Thank you. All right, Mr. McCann. Good to see you, sir.
Good evening, commissioners. I'm Kevin McCann. I'm a lawyer in Merritt Island, and I represent the Rockwell South Homeowners Association. I don't want to repeat everything that's been said, but I do adopt everything that was said and make it my own words as well. I do take quite offense to a comment made by Mr. McGuire calling it action, an illegal action going on right now. There is litigation over Currydale Lane and who the owner of Currydale Lane is. I will say, without going into much details about the litigation, Currydale Lane is within the Rockwell South Homeowners Association. It has been since day one. Mr. Curry was the original developer of that property. Consists of 11 parcels. There's a retention pond parcel, there's the street parcel, and there's 9 residence parcels. That is the Homeowners Association. What Mr. McGuire wants to do is he wants to take that street away from the Homeowners Association and make it his, so he can access his property and put in 11 to 12 residents on that vacant land. That's the litigation that's going on right now. He didn't mention it in the Planning and Zoning Board meeting. He actually made a comment and acknowledged in that meeting that Currydale Lane is a private road, and he knows that he cannot access it for access. He cannot use it for access. It's in the agenda on page 98. He made those comments in Planning and Zoning. I would like to say that Planning and Zoning did not have accurate information when they made their vote. They voted, I believe, 6-1, or 1 opposed and the rest for the rezoning. But they did not have at the time the information that Mr. McGuire had, and that this road is actually in litigation. Mr. McGuire is trying to get access and ownership of that road so he can build his development on that very narrow strip of land. As we know, that I believe staff mentioned earlier, that strip of land is so narrow that he can't do his development without accessing Currydale Lane. So I want to make that clear. I want to set the record straight that that is what's happening outside of the Planning and Zoning Board meeting that took place, and I think that's fair to allow the commissioners to know prior to their vote that inaccurate information was provided to the Planning and Zoning Board meeting, Planning Board during their meeting. And I think that information is extremely important for their vote. In addition, I would like to not necessarily disagree with you, Mr. Lober, but SEU zoning is very prevalent in that area. The entire strip of all the waterfront properties on Banana River Drive is zoned SEU. This piece of property itself extends all the way to Banana River, to the Banana River. If I said Banana River Drive, I apologize, but all the SEU properties align the Banana River. And this property itself is waterfront on the Banana River. It extends all the way to the Banana River. It passes South Courtney and hits the Banana River. There's almost 2 acres of water, wetlands from the Banana River up to and past Courtney into where he wants to develop those 11 properties. Both properties south and north of the parcel that extends to the Banana River are SEU. SEU extends several properties up and several properties down along the Banana River. Mr. McGuire does have a plan to put a residence on that parcel right on the Banana River, which is 100% wetlands. He provided his plans to us, and we have that, and I want to put that in the record.
If you'd like, you can also use the projector. I'll pause your time for a moment. We get that set.
You want to?
Yeah,
Okay.
I think for everyone to have a good view. Don, could you help him? All right, I'm going to restart you here. Okay.
All right, thank you.
Yes,
So-
sir.
So this is the property with his primary desired plan to take place. He's got 10 parcels that align Currydale Drive just to the south of it. All the residences on Currydale Drive are on the north side of Currydale Drive. So he wants to occupy the southern side of it and take up that entire strip of land and put all those residents in there. He then has a flag lot on South Tropical, which is to the west and on the left side of the screen. And he has a waterfront property, which he plans to develop, or plans to at least attempt to develop, right on the Banana River, which is this strip right here. That's part of his parcel. That entire black in area is his parcel. All these properties to the north here and properties to the south are SEU, suburban estate use zoning, residential zoning. I think it's completely appropriate to consider SEU as a potential zoning classification for this change.
Mr. McCann, I'm going to have to ask you to wrap up. You're pushing over time here.
So in conclusion, I feel as though Mr. McGuire provided not full, truthful information to staff and to the board. And I want to make that clear. I think the board has the right to know that before they vote, and maybe they should reconsider. And I also believe that this commission should know that as well. And we also request, if you're going to consider a zoning reclassification, that it be consistent with other very dense zoning in this area, which is SEU.
Thank you, sir.
You're welcome.
All right, a question for staff, perhaps for Ms. Bentley. If we have both EU and SEU in the area, what degree of flexibility, if any, do we have in offering up an SEU zoning instead of an EU zoning?
I'd like to confirm with Tad and Jeffrey that the SEU zoning is a less dense zoning classification.
That is correct.
Yes.
It's less.
Is it a half acre minimum instead of a third, or is it even larger than that?
It's 1 acre.
1 acre
minimum.
instead of a third, okay.
The way your ad is run, it does provide that you can consider other zoning classifications that are of a greater density when you're going from AU to EU. Anything in between basically would be available.
So the SEU would be something that we're permitted to
Yes.
offer up? If there were, well, bear with me, I'm just thinking aloud for a moment in terms of how I want to phrase this. If the motion were to approve, well, let me ask differently. Would we need the applicant's consent to move to approve it as SEU if the board's not inclined to approve it as EU?
Not necessarily, no. Anything that's advertised can be considered.
Maybe
You might want
that's-
to inquire.
Say again?
Why
Inquire?
Okay.
Because to me, maybe that's the way to resolve this, where it is consistent with the nearby. There is SEU nearby. There's certainly an argument for that, as opposed to just saying no outright. And that would enable him to develop his lot, or I should say his subject property, reasonably. Maybe that's the way to go about it. Well, let's have him come up for a moment. I think you have a little over 14 minutes left for rebuttal, sir.
Hi, Michael McGuire again. A couple points I'd like to point out is that currently this is AU. There is not enough frontage on Tropical Trail or South Courtney to meet the requirements for an AU lot. When I went in to meet with planning and zoning, they told me that the only zoning that was allowed for this property was EU. The abutting properties to the south and to the north are EU. The house sizes required by EU is 2,000 square feet, which is comparable to the houses on the north side of Curly Dell Lane. The property has been owned by Mr. Curry since he developed it. He saw fit to leave it, in my understanding, to his daughter through his estate. His family is suing for control of this street. I am not suing for control. This property will not devalue their houses because it'll be the same size almost per square foot of lot and of house size, but there'll be newer houses. I believe that this is the right zoning, and that if you were to look at what's required by the law, that this is the right thing to do, and it's, I believe, the only thing you can do. I'm finished.
I appreciate it. Commissioner Isnardi?
I just want to say, I see staff scuffling around down there and some questions going back and forth. I was just wondering if you had any input on this, any information you could share with us, or concerns or input.
Sure. So you have seen us looking around. We just want to make sure there's been a lot of information provided to you all. So we just wanted to make sure that we were able to answer any questions that may come your way. So, you know, as mentioned earlier by Commissioner Lober and by the one gentleman, there is SEU in the area, and SEU is compatible or can be considered consistent with the land use. That is a larger zoning classification than what's been requested. It's a 1 acre zoning classification. The minimum lot size for that is 125 feet by 125 feet. I believe that this lot is somewhere between 130 and 140 feet. So while if you go with the larger lot, it still doesn't alleviate the concerns or the waivers that would be necessary for doing a subdivision. So, I mean, you're still going to have the right-of-way constraints and stuff
And I
like
think
that.
that was going to be my question. If they can build one less house, is it really going to be that much of an impactful difference? And also, too, if you look to the properties, and I'm not for or against either way, this is your district, but if you look to the properties south, you have the property that's up to be changed now is AU, the one directly below it is SEU, then it's EU, then it's EU, then it's AU, then it's EU, then it's EU. I'm just saying, like going headed south. So it may be more SEU to the north. There's much more EU to the south. But Ted, realistically, is it 1 or 2 less houses, like 9 as opposed to 11, if you're talking lot size?
The lot is 6 acres, so if it was 1 acre, you would have by limit, you'd be limited to 6. And I'm sorry, I misread this. It's 125 by 200 feet.
Oh, that's a big difference.
It's a big difference. My apologies.
I guess what I'm just trying to understand is, why is it okay for the properties to the north? I know that what they signed up for, and they were hoping that wouldn't be developed, but that's not their say, especially if, the original property owner decided, or the estate person decided to sell the land. I mean, I don't know. I understand both sides, I guess.
And just from my perspective, it is solidly in D2, although it's kind of inching down toward D4, Commissioner Smith. I would be happy with SEU. I still would ask whether a motion comes up to approve it as SEU or as EU, to have that language that I read at the beginning, which I'm happy to repeat again just for clarity's sake. If the applicant consents to SEU, I think all the issues, at least for tonight's purposes, are resolved. I understand that there still, in all likelihood, will be waiver requests that come in, and they'll have to be evaluated as they come in. But I certainly would feel better knowing that there are fewer septic tanks being plugged into that little area, irrespective of what's there. I can tell you, if you look at Rockledge Drive, going up into Cocoa and down into Rockledge, the fact that there are a slew of houses there that have septics, many of which are decades old, polluting the Indian River, doesn't make me feel better about adding more septic tanks, even if they're advanced septic tanks, right in that area that's sandwiched against a body of water. This is perhaps even worse in the sense that it's sandwiched between 2 major bodies of water on a barrier island, as it were. So I just think anything we can do to limit the density in that area, given that we don't have the option for folks to hook up to sewer, to me, that's a concern. That is a big concern on the environmental standpoint. As far as the Gopher Tortoises, I understand, and Tad, you certainly have a better understanding than I do, that there are policies in place addressing that. So it's not that they can simply pick them up and say, hey, little guy, we're now going to put you in Cocoa Beach or Rockledge. I think that may be a problem for them that they have to address at their cost, should that be an issue. But, again, I don't know where folks are. I certainly would support SEU with the caveat that staff not be directed not to administratively grant any waivers of any development standards without the express approval of the BOCC, and that staff be further directed to apply the most stringent lawful standards in analyzing any such waiver proposal or proposals. I could support that. I've got to tell you, I think with what I've heard, I didn't think that I'd be voting against an EU proposal, because I did feel that we were a little more constrained than I now get the feeling that we perhaps are. I don't believe that I'm in a position where I can support an EU zoning tonight. That said, I respect where everyone else is, and you need to vote how you see fit and what you think is appropriate. But my concerns are my concerns. So, Commissioner Tobias.
Thank you, Mr. Chair. And a question to the additional motion. Is that just subject to this property, or is that all future requests in all districts?
Subject to this property, that's the subject property for the agenda item.
Okay, so it would have no... Mr. Chair?
Yes,
so
sir.
it would have no impact on future zoning change requests, correct? Other than this...
Other than the subject property, it's not contemplated as involving any other piece of land, no.
Thank you.
Sure. So with that, I think, to be frank, I think the guy's entitled to have something approved to let him develop the land, regardless of you know, how nice it would be to have it vacant, but
Is my light on?
hit it again. You're on there now. Okay, yes, sir. Commissioner Smith.
Well, the way I look at this thing, from my perspective, you have two very sensitive bodies of water on either side of this property, on either side of this peninsula. And to put more septic tanks in as opposed to less doesn't float my boat, no pun intended, because we're talking about water. As I look at this, I'm thinking that it's very difficult for this developer, no matter what we decide, because unless he can access, and Tad, correct me if I'm wrong, but unless he can access Curry Dell Road or Curry Dell Lane, he's not going to be able to get lot size and room for a roadway within his property. Is that correct?
Yes, sir. So that's where the waivers would come in, which Commissioner Lober is requesting that we bring back before you
Right.
if they get into the subdivision. So if they did a formal subdivision where they were proposing to construct a roadway, then, you know, we would be looking at 50-foot of right-of-way width.
Right.
And that they could do a minor subdivision where they take access off of, what is it, Courtney and
South Tropical Trail.
South Tropical Trail, but then they would be limited to the lot widths, and so they would not be able to get the lot yield of 11, 12 lots. Then they would be limited to about 4 lots, if that were the case, 3 lots, depending on the zoning classification that the board granted.
Well, I'm not crazy about septic tanks in there anyway. In fact, your predecessor sat on this board, and he adamantly said that he would not be in favor of any development in the county unless it had sewer. So I'll make the motion that we listed at SEU, and I'll include that because I can't remember all those words.
Okay, so contemplated with the motion, staff shall be directed not to administratively grant any waivers of any development standards without the express approval of the BOCC, and staff be further directed to apply the most stringent lawful standards in analyzing any such waiver proposal or proposals. Sound good?
That's exactly what I was going to say.
I figured you were thinking that. All right, I'll go ahead and second that. Ms. Bentley, do we need anything, or is there anything else beneficial that we should chime in at this point?
I think you've covered it.
All right, any further discussion? All right, seeing none, I'll go ahead and call the question. All in favor of the motion as stated, say aye.
Aye.
Aye. Any opposed? Passes unanimously. Thank you all. All right, bear with me. I'm just going to get my bearings again. We've done H2. We've done H3. There's nothing in I. We have one item in J. If it's all right with folks, I'd like to take public comment before we deal with J1, just because there are only a couple cards, and I'd rather not make the folks sit here for what may be a long item. Is that all right? Okay. All right, so for item K, we've got 2 public comment cards. We have Christina Jackson from Cocoa and then Sandra Sullivan from South Patrick Shores. So, Ms. Jackson, if you would come up. Oh, do you want to, yeah, if you want to wait, Ms. Sullivan? Do you want to come up for K? I'm thinking if there are a bunch of cards for the other and only 1 or 2 for K.
Good evening. Sandra Sullivan, South Patrick Shores. I'm here tonight about the issues with the Hightower Preserve and the South Base housing again. So a couple of different concerns. One is the intent, and I've been doing records requests. The intent initially that the density on the South Base housing was capped at 999 units. And it was, the Air Force had come to the city and the county with their specification of what they were looking for to privatize, and they wanted 1,572 units. The bottom line is under Congress, they have to approve the development plan as part of the Congress granting them the right to privatize. And they did that in 2004 for the Pelican Coast. Now, the PUD in documents I have here, which I'll leave, was explicitly met their specifications as agreed by the Air Force. There's a couple of things I would like to ask of this board. From your own objections that you wrote when the city one added the 366 units, you wrote a letter of objection to DCA. And so that, because that violated the intent of the preserve agreement and no density bonuses were allowed. There's two things, and I'd like maybe if you guys would answer about this, but apparently on the city's resolution 631, it says that the county commissioners has the legal authority under your county charter and provisions of general laws of the state of Florida to adopt ordinances that are effective in both the unincorporated area and the municipalities. I'm asking for you guys because you guys were partner in one preserve agreement and co-applicant. They both required the same changes to the comp plan to cap the densities. And then the city went a step further. The city represented to the local residents that they were making a clerical change to match the zoning to the PUD, but what they did, and is shown intent by the packet, they gave the developer the right to a hotel. So now instead of the 1,365 units is now being pushed to that units and a hotel. This is going to adversely affect a preserve which was funded with about $5 million of state funds. And the county was a partner and a co-applicant on the two preserve agreements. We're asking if you will take action to help protect it, either one, by an ordinance, or two, with lobbying to the federal government to, one last sentence, to deny the current development plan, which has not been agreed and violates their own specifications that they specified and agreed earlier.
Thanks. Ms. Bentley, I may ask you sometime between now and the next commission meeting what we are entitled to do on that end. I just would like to do a little more recon before I comment on it. I just don't know that I'm in a position to do that intelligently at the moment.
Thank you.
Thank you. All right, so we'll hold off on Ms. Jackson, who wants us to address J1 first. And bear with me just a moment. I'm pulling that item up here. And just for everyone's benefit as well, we've got 3 cards. I thought we had 4, but we only have 3 cards on J1. We have Ms. Jackson up first from Cocoa, then we have Dina Ryder-Hicks from West Melbourne, and then Barbara Gorin from Vieira. So I think at this point, rather than just introducing the item, which has largely been described in the agenda report that I put on there, I'll just go straight to public comment. So let's start up with Ms. Jackson. Welcome.
Thanks. So this item is incentivizing people to look for fault and make complaints. If you made 1 complaint a month and this lasts the 7 years of the contract, you can earn $2,100 from the county just for making complaints about a company. And so is there a limit to the number of times an address can complain? If you complain twice a month, you make $50. You can make $4,200 a year complaining. Or in 7 years, I'm sorry, in 7 years complaining. I mean, that's good money for people. How is a complaint validated? I mean, we forget to put out our trash. A lot of people do. Can we validate that? Can we validate, did the person forget and they're just, oops, I forgot, let's make some money off this? And if this is done, I think you need to send out notices to everybody on the route. Because I only know about this because I have a subscription to a newspaper. But when I was an 18-year-old single and pregnant, I could not afford that. So people who can't afford a newspaper subscription won't know about this. So they deserve to know about this program if it's approved. My 16-year-old, when he heard about this, he said, if you want to get an accurate account of what's occurring, pay people money to do a survey. You'll hear the good and the bad, and they get paid for it instead of just paying for complaints. I mean, there's a reason people don't pay for complaints. You want a complaint to be valid. You want a person to spend time making a complaint. I mean, it took time for me to come down here, prepare a speech just to do this. If I had gotten paid for it, I might be here more often. Where is that $50 supposed to go that the company's getting paid for? I mean, Waste Management, it said, is giving you guys $50 for every complaint. Where is that money going? I mean, the public didn't know about this until this was brought up. We're told that the county is bleeding money. Public record prices went up extensively. So doesn't the county need all that money? How can we afford to give half of it to the people when we're needing money? It's said to help pay for the time the staff is spent on their job doing this. But that's kind of the job of staffers. I mean, I wouldn't want it, but you take calls about complaints, about inquiries. That's just the nature of the job. So do the complaints, do they help people's trash service? What are the complaints? What is this $50? What good does it do? Are we just wanting to bleed the company dry? Are we upset at the company? What other company is going to want to offer a bid after this? They did in good faith, I assume, a $50 for each complaint. I doubt they thought it was going to be publicized. We'll pay the people money to complain. If I was the company, I'd be outraged. I mean, we said you could do this. My mom, pays 1 day a week in Wichita, Kansas. You get trash service 1 day a week. You have to take your stuff to the dump. And she pays $30 a year more than we do here.
Ma'am, I'm going to need you to wrap up. You're a bit over time.
Okay, so with this, like I said, just taking, it seems, especially during COVID, where we forgive companies. When you call customer service, it says, due to COVID, expect longer wait times because we're trying to protect our workers. I mean, during this time, most of us are forgiving to companies. Walmart's only open until 10 p.m. instead of 24 hours a day. We understand this. Not in this case. So I'm asking you to say no to this proposal to pay people, especially during a pandemic.
Thank you. Commissioner Tobias, you have a question, sir?
Thank you, Ms. Jackson. Thanks for coming here. My question is, why are you so passionate about this issue? Do you have a relationship with Waste Management or someone in your family? I'm just trying to figure out.
No, I was just so frustrated by that idea. It just seemed like another personal vendetta possibly against a company that's been known to happen to maybe Health First, a business owner who was representing other businesses who did an email. There was a personal vendetta. This seems like a personal vendetta more than it does.
I think you've answered this question, ma'am.
Thank you. Yeah, I didn't know the answer, Mr. Chair.
I'm
Sorry.
sure you didn't.
I don't know him either. So
someone may believe everything they read.
No relationship there.
But thank you, ma'am. I appreciate that. So I will, and we'll have Ms. Ryder-Hicks kind of come up on deck here. I will address a couple things that came up. I do agree with the prior speaker that we do need all the money that we're entitled to collect by way of damages. And by encouraging and incentivizing folks to make valid complaints, again, valid complaints, in all likelihood, we're going to be receiving more complaints that we otherwise wouldn't have received. So getting a large percentage, 50 to 60% of a higher number, in all likelihood is going to be getting the entirety of a far lower number. As far as making $4,200, if folks not only didn't believe everything they read, I guess they believe sporadically, depending on the author, everything they read, but the proposal actually had it capped at their cost of service. Yuri, what is the cost of service for the average individual over the course of either a year or 7 years, so we can look at the numbers here?
The current contract is the one that ended last week, or yesterday, which is the one under discussion, was around $135.
$135 over what period of time?
A year.
So if we capped it at the cost of service, the $4,200 is an actual impossibility that was suggested someone could make. Is that a fair assessment?
If we cap it, yes, sir.
And that the cap was proposed in the actual agenda item, was it not, to your understanding?
Yes, sir.
Okay, so that's a fallacy as well. With respect to the validation of a complaint, Yuri, I am well aware, but for everyone else's benefit who simply assumes that they know the entirety of something based on a short article, would you mind giving us a little background on how your department goes about validating complaints?
Okay, there's two sources, or two or three sources of complaints. Number one is through the internet, which has increased recently due to the publicity that we've been giving it out. Calls coming in, emails coming in, complaints that commissioners forward us, and complaints that are called directly into the Waste Management website. Every month we get together and we compare notes. They have, depending on what type of complaint that we're talking about, it could be anything from oil spills all the way down to missed pickups. All of them have different days in which they can be cured. Some of them can be cured, some of them just for occurring are automatically susceptible to liquidated damages. In the case of missed pickups, we're talking about they get 20 that are at no cost to Waste Management, just 20 out of 1,000 or 100,000 homes that we serve every month. So percentage-wise, that is extremely low. Then we look at, did we communicate with Waste Management and tell them that there was an issue? We have to have proof of that. We have to have proof that they responded to us in a manner, and after that we make the determination on whether it is susceptible to liquidated damages or not.
Is that something that your department is capable of doing?
That's what we currently do.
Okay, so there's no issue, to your understanding, with your department's ability to actually validate complaints?
No, it's just a matter of volume. It's not a matter of process. The process would be the same.
All right. Are you aware of there being any talk of a vendetta between Waste Management and myself? And I'll ask Ms. Ryder-Hicks of the same question as well. It's news to me.
Not to my knowledge, sir.
I appreciate that. Ms. Ryder-Hicks, if you'd come up, and I've got just a couple questions for you before you start, if you don't mind. Do we have a vendetta that I don't know about?
No, sir, we do not.
Okay, I was going to say, I thought we've been pretty cordial and pleasant with one another. But lastly, before I give you your 3 minutes, do you believe that the county is able to validate complaints submitted to the county?
As Mr. Rodriguez suggested, we do have a good process in place. We do review for what is considered a legitimate complaint, and per the contract, anything is considered a legitimate complaint unless appropriate disposition is furnished. So we discuss all of those items and make sure that for any of those items that are out there that we have appropriately provided a disposition for the resolution of that complaint.
I appreciate it. I'll go ahead and give you your full 3 minutes, ma'am. So you've got the floor.
Very good. Thank you, sir. And good evening, Mr. Chairman and distinguished members of the Commission. I am Dina Ryder-Hicks, Public Affairs Manager with Waste Management. Thank you for the opportunity to speak with you here this evening. Please allow me to begin by thanking you all for your support. We've held a long, solid relationship with Brevard County, and we've had our share of ups and downs. This summer was one of those down periods, as COVID-19 presented a unique set of challenges for all of us every day. Please accept our sincere apologies for any difficulties that may have been experienced by your offices, and we apologize for any inconvenience to our residents. We do understand. Our drivers, our managers, our dispatchers, and me, we all live here too. We want to return to the exemplary service that you deserve and have come to expect from Waste Management. There is no one who wants our service to be exemplary more than those of us who work for Waste Management here in Brevard County. I'm pleased to report that we've seen considerable improvement throughout September, and I'm confident you will see service continue to head back on track in the coming weeks. Today is the start of our new franchise agreement with Brevard County, and we thank you again for selecting Waste Management as your service provider. Today brings with it new and additional trucks to service Brevard County, as we had discussed last November. We have added brand new high-capacity grapple clam trucks to service large yard waste piles in our area. Today also brings additional personnel that have come to us from servicing another area within the county. These are all Brevard County residents and are quite familiar with our area. These added resources mean that we are adding more service routes within Brevard County to serve our expanding population. In the past several weeks, we've hired additional personnel and have promoted from within and recently named a few new route managers for our residential services. These new employees, along with our existing employees who are segueing into new roles within the county, will help us get our service back on track in short order. I'm confident you will see marked improvement in the coming weeks. As trying as it has been, we thank you sincerely for your patience and support and for the continued confidence and trust you place in Waste Management. Thank you.
Thank you, Ms. Ryder-Hicks. And I'll add as well, if I could. My concerns over the past with respect to Waste Management, none of them whatsoever have involved you. I think they have a real good asset in keeping you with the company. I think you've been stellar to work with. I don't have any complaints in being able to reach you. I don't have any complaints with respect to the issues that I brought to your attention not being resolved correctly. I think everything has been dealt with timely and well when I brought it to your attention. I don't want anyone to mistake this agenda item as any sort of a slight to Ms. Ryder-Hicks. It's not. I mean, I can just say it as bluntly as that. I do want to add with respect to what's proposed. In an ideal world, our goals are totally compatible, and I know we've discussed this as well, but just for everyone's benefit that wasn't party to the conversation, I don't want to see any liquidated damages because I'd love to see all the pickups go perfectly and seamlessly. So in an ideal world, we vote on this, it passes, and we don't assess anything. We don't look to enforce anything because every pickup is addressed as scheduled and there are no issues. That's what I'm really truly hoping to see. This is something I think that helps better ensure public confidence, and I understand that things may happen, some of which may be largely tied to COVID. I'm not saying that's not the case, but I think now that you have more resources that you've brought to bear and continue to bring to bear, now is a time for us to kind of look at this fresh. I think that the folks that live here that do have waste management service will gain a degree of confidence knowing that there is a mechanism in place should there be any sort of service issues in the future, but it is my hope that there aren't any. So I don't wish Waste Management poorly. I'm certainly a lover of capitalism. Waste Management, I understand, is publicly traded. I hope its stock price goes through the roof. The better Waste Management does, it's not that it harms the county or harms the residents. I just want to see everyone benefit from this, especially the folks that are scheduled to have their pickups from Waste Management. So we've got one more, Ms. Hicks, and then we'll see where it goes.
Thank you, sir.
Thank you. Barbara Gorin from
Mr.
Bureau.
Chair?
Yes, sir.
I'm sorry.
I apologize. I must not have seen it. Yes, sir.
No, I was just wondering, do we have any videos extolling the virtues of Waste Management this meeting, or did you not get around to make one this time?
I'm so sorry, Commissioner. I missed the question. I apologize.
That was probably a good thing, Ms. Ryder-Hicks.
I'm so sorry.
Just wondering if we had any videos this time.
Oh, not this time, sir.
Okay.
I'd be happy to provide some if you'd like.
Okay, I appreciate it.
Thank you, sir.
Maybe perhaps Commissioner Tobias like to tour one of the grapple clam trucks that was just added to the fleet.
I'll take your word for it.
We would welcome that. Absolutely.
Perhaps we could scoop him up with the grapple clam. All right. All right, I'll stop, Ms. Gorin. Welcome.
Good evening, Commissioners. Thank you for the opportunity to talk. I was shocked, number one, when I saw the size of the cost of the service go up so much. And we've got so much new development in here, and I know this isn't the forum right now to talk about it, but there are so many new homes that are going up right across the street from us up there in Vieira. And for it to go up that much with these new homes going in, it just blew all of our minds. It kind of caught us by surprise because with COVID, I didn't get to come in and voice an opinion and didn't have time to organize any of our people that came in here the last time when we had this out for bid. But we're going to have increases in cost through the 7 years. We did the last contract. And it just does not seem fair that seniors have to pay that much more to have their garbage picked up. It's just, it just cuts right deep because we're not getting any more for the money. I would not expect the service to go down. And so I don't know what all these new businesses and all these new homes, where their money is going, that ours would go up the whole thing would go up 39%. And I will say that they have been really good in Heritage Isle. We've only had, it was just about 2 weeks ago, within the past 3 weeks, there was one day that was missed, but they picked up the next day. That's doable, but I wouldn't complain about that. But if it happened on a regular basis, I would really put my 2 cents in to let you all know that I'm unhappy. But I just had to get that off my chest. It's just been a rankle.
Understood, and I would certainly encourage you to add your 2 cents should that be the case, but hopefully, as Ms. Ryder-Hicks mentioned, with the additional resources they're bringing in, I hope that's not the case.
Thank you.
Thank you, ma'am.
Okay, thank you very much.
All right, that's all we have by way of public comment. Yuri, I don't know, just briefly, for everyone's benefit, if you could reiterate the cap with respect to increasing costs throughout the duration of the contract.
The contract has a CPI increase on it that is capped at 3%. In other words, cap means that if the inflation is 1%, they cannot ask for a 3% increase. All they can do is ask for a 1% increase.
So it's the lower of CPI or 3% then?
Yes, sir.
I appreciate it. Thank you. All right, I'm happy to kind of reiterate what's already in the agenda item, but I think everyone knows what it says. So, I certainly would accept the motion to approve it, or if folks want to discuss it, we could go down that route, whatever you all want to do. Do we have any dramatic music that we can play, Logan? No one? Commissioner Pritchett?
Am I on?
Yeah, you're on now. Yes, ma'am.
Well, I got a couple struggles with it. We're already finding them, which is a good thing. So I think what this is going to do is incentivize people to call in that aren't currently calling in. So my struggle with this is when they miss a garbage, it's costing them, what they're paying is like $1.30, and we're going to give them $20. That's quite an extensive amount of money we're paying them for that. So I don't know, kind of struggling with that. I think the one lady hit on that I just got a little check with this. In District 1, and I've been very frustrated, we've had most of the complaints. Our complaints are going down. I think in September I had 7 complaints in our office, and we had 4 this time. And through the whole time I've been on commission, we usually get 1 or 2 a week regardless. It's just been the nature of it. So I do see some improvement. We just started the new contract October 1. So I don't know, guys. I think this is something I would have maybe thought a discussion in about a month might have been a little more appropriate. But I don't know that it's not starting to get a little bit fixed right now. Because here's the thought, too. If we do this, and it's got to be validated with all the new ones, and all of these people are contacting the county, that's going to spend more staff time. You're going to have to add staff to do this. And then I don't know if there's not going to be an argument with what's validated or not validated, how long that's going to take. So we're going to have to increase staff to do it. And then we're going to have to send the check, mail the check. And then I don't know if it's fair if somebody misses 5 or 6 times to not be paying for any garbage service the rest of the year. Now, I don't have a problem with the $50 fine because of what we're trying to get in place. That kind of shares the love with the whole community later when we try to get more waste management. So these are just the concerns. And then if we do this with them and say they can't fulfill it, and if it's really this bad, maybe we should go out for a bid again. But if they can't fulfill it, I'm concerned of somebody else wanting to place a bid with the county, knowing that we are now high risk, that we charge extensive. We promote the fee base. So I don't know. I've just got a little bit of struggles on this for the long term, and I would like to hear some communication from you guys on your thoughts.
Commissioner Zardi?
I don't have a problem. Obviously, there's a system in place, to pay a fine or whatever if we miss pickups, but I don't like the idea of incentivizing complaints, only because I think, again, that you're kind of telling people, well, if you miss a complaint, you can file and the county's going to pay you. It It doesn't feel right. Now, I think obviously be as aggressive as we can if we're missing. If people are missing pickups, then I want to make sure that we are able to recover those fines. And maybe, you know, as an alternative to this, because we need to hold Waste Management accountable, and I'm really excited that they've gotten some new drivers. But if that's the case, we take that number at the end of the year and we reduce trash rates for everyone, or we give them back a piece of those fines instead of the county keeping those monies, you know, because really, ultimately, it's the customer that was affected. Then I think that's how we give those monies back to them. But to incentivize complaints, I don't want to be in the business of doing that. I think that's kind of a slippery slope, I think. So.
Commissioner Tobias?
Thank you, Mr. Chair. Yuri, I guess it's $20 or $25, depending on whether it's an online submittal or over the phone. In your opinion, would we need to add staff to, and I know you can't predict the number of complaints, but I don't know, how long does it take to verify a single complaint?
If we were to continue to receive at the current level that we're having, we would not have to add staff. If we were to get additional complaints, yes, sir, we would have to consider that option. And as far as validating it, we validate it anyway,
okay,
regardless of it.
But to be clear, if there were more and you would need additional staff, we would also incur additional revenue, correct? Because that would be additional $50 fines if 20 or 25 went to the person registering it. The other 20 or 25 that we wouldn't otherwise have would then come to your department.
Yes, sir.
Is that fair?
One goes along with the other, yes, sir.
Okay, so while there may need to be more staff, it may be covered. Is that fair?
Yes, sir.
Okay. Mr. Chair, I don't know that you have the votes on this one, but I think that incentivizing behavior is something government does. We do it all the time. We need to tell the sheriff to stop offering rewards for people that give crime tips to turn in people that have done bad things in this community. So I don't think this is all that radical of a proposal. I think Waste Management and this commission want the exact same thing. I think we both want less misses and less complaints. And if that's the goal, then whether we offer $20 or whether we offer $50 or whether we offer $1.33, if they're not there, then there's no reason to complain. So, Mr. Chair, I'll join you on this one. I'll even make the motion so you don't have to pass the gavel. Perfect. But I don't know that you have a third on this one.
Well, let's find out here. Commissioner Smith, and then I'll jump in again.
Well, you don't have a third with me.
Shucks.
Just right up front. We have a brand new contract with these folks. We've got a history with these folks. We have remedies in place in the contract if they fail to do their job. I don't think we need to invent new ways to come up with new remedies. If we get to the point where it really gets bad, then I think we can revisit the issue. But I don't think this is the time.
Okay, I'll go ahead and jump in. And if it's a losing ship, it's a losing ship, or a sinking ship, I should say. A few things. First, Commissioner Tobias, you hit on the fact that revenue increases will offset any additional costs that we have by way of staff. A large part of the reason that this was introduced, I should say really the reason it was introduced, was right around the time that residents were facing and are facing a 39% increase in their collection costs, which frankly was unavoidable. It's a slap in the face to say, okay, now pay almost 40% more and have missed pickups. I understand the concern about incentivizing folks insofar as it might encourage folks to file complaints that aren't valid. But we would quickly see who those folks are that are filing those complaints and give complaints from those sources their due amount of warranted attention. Using the liquidated damages to reduce the pickup costs for everyone is certainly much, much, much better than doing nothing with it. I think it's better than building our reserves at this point in time in that particular department. But as Commissioner Rosnardi pointed out, ultimately the ones that are affected most directly are the customers. Those folks that don't have their trash picked up on a particular day are the ones that have to smell the rotting turkey and chicken until it's picked up the next day or 2 days later, whatever the case may be. So if someone ends up having 7 missed pickups or however many missed pickups it may be, and that essentially comps the cost of their collection for the year, they should have had those 7 days with proper service. I don't have any qualms incentivizing people to report behavior that goes toward our contractual remedies. I'm not looking to invent remedies. I'm not looking to add to the remedies with respect to waste management. I'm simply seeking to put ourselves in a better position whereby we can enforce those remedies that are available to us to the maximum extent possible. It's the same thing when you look at speed limits. If you have a car and you want to goose it, if you know that there's a technical prohibition on it, but no one's going to enforce it, you're probably going to go ahead and goose it. On the other hand, if you know that there are police sitting there and your radar detector is going off, you're probably not going to speed, or you're not going to speed much. This is something where I'm not saying that waste management would intentionally not pick up trash, but I think anything that we do to incentivize service that gets closer to perfect service, the better. I'm not upset that waste management has moved resources. I'm happy they've moved resources from their other contract on the south end of the county and kept those people on board without letting them go. I think it's to their benefit and to the county's benefit. I hope that we don't need something, but I still do worry about the folks who are now paying more should they continue to have issues with respect to their service pickup. So I'll leave it at that. Commissioner Tobias, if you want to make a motion, I'll second it and we go down in flames, or we can let it be, however you want to handle it.
It was your agenda item, so.
You want to do it?
I have to. Okay. Okay, I'll make a motion to approve the financial incentive for constituents reporting of waste management missed pickups.
I'll go ahead and second it. I think we've discussed it, unless someone wants to add anything else. All right, I'll go ahead and call the question. All in favor, say aye.
Aye.
Any opposed?
Nay.
All right, fails 2-3 with Commissioner Tobias and myself in the affirmative, and the remaining commissioners, Smith, Pritchett, and Rosnardi, in the negative. Almost goofed on that one. Commissioner Pritchett?
Yeah, I just want to state that I hope you guys continue to do better. And we're on the phone with you probably 3 or 4 times a week. And so I appreciate you working hard towards that. Just a quick thing. In 2014, we collected $222,000 worth of fines. In 2018, $24,950. 2019, $15,450. And this year, we're at $13,700. So we do collect fines from them when they don't pick up. And I don't know about you guys, but I know we get calls from the ones that miss. And every once in a while, if you miss, and somebody doesn't call in. So I think what we have is working. And I just want to encourage you to continue to get the improvements done. You're in your new contract. And I'm really looking forward to that, or you're going to be hearing from us every day again, Ms. Dina. So thank you.
And I'll join Commissioner Pritchett in saying that I do hope things go well. The end goal, as has been mentioned ad nauseum, is to have good service, to have consistent service. Hopefully today's vote won't make a difference, because service will be at the level that there wouldn't be any liquidated damages to even worry about. So, I appreciate you coming out. I appreciate you remaining reachable. Hopefully everything goes well and smoothly from here on out. Thank you. All right, so we have, I don't know if Ms. Jackson from COCO wanted also to speak on item K as in kilo. She left? Okay, I guess she left. All right, so we don't have any further public comment. So we'll move on to board reports. Mr. Abate, do you have anything, sir?
No, I do not.
How about Ms. Bentley?
No report.
Commissioner Pritchett? All right, I'll save mine for a moment here. Commissioner Tobias?
No report, Mr. Chair.
Commissioner Smith?
No report.
Commissioner Rosnardi? All right, I've got one here. So we each wear a number of hats in life, and especially me, as I'm balding. As you may know, I'm an attorney, I'm a mediator, I'm also an avid shooter and diver. Less avid shooting with the price of ammo and the scarcity of it these days. As an attorney, as a mediator, wearing these other hats, I have been and I remain involved in a number of different legal and civic organizations and groups. This commission, at least since I've been on, to my knowledge, has never rejected any commissioner's request to obtain an AGO. So as such, for the first and potentially last time from my office, I couldn't begin to predict the future on that. I'd like to ask for approval to request an AGO to confirm that one or more planned activities of mine won't conflict with my service as a county commissioner. I already, in fact, have a lot of the legwork done in drafting the request, so as such, I don't think it would take more than a couple of hours of the county attorney's staff time. So if someone would be kind enough to make the motion, I'd certainly appreciate it. All right, we have a motion from Commissioner Pritchett. I'll go ahead and second it. I'll call the question. All in favor, say aye. 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 Any opposed? All right, seeing none, passes unanimously. Thank you. All right, we'll go ahead and adjourn here at 6:29. Thank you, everyone.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.